You're ready to start your trial. You've been waiting 2 long years to get to trial. Can the judge make a ruling immediately before you start your trial that will totally affect how your attorney is able to introduce certain evidence? You want to learn the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is yes. Right before you actually start the trial, one attorney or your own attorney can ask the judge for what's called a motion in limine. What is that? That's a fancy way to say, hey judge, I want you to make a legal ruling upon an issue that I know is going to come up during the course of this trial. And I have to have an answer to this issue before we start the trial. So this way we don't have to interrupt the proceedings, and now you don't have to make a legal ruling in the middle of the trial. Will you do that? And now the judge will ask, what's the issue, counselor? And that legal ruling can certainly affect how that particular evidence gets introduced or not introduced in your particular trial. And that could change and alter the outcome of your case. So here you are preparing for months mentally as your case gets closer to trial. Your attorney has been preparing for months, getting your experts ready, getting subpoenas out, getting medical records into court, and now preparing different witnesses to come in and testify. And now, right before trial, literally, you're in court. Your attorney goes to meet with the other attorney, and they go to speak to the judge. Judge, I have an issue that I need you to address. What is it, counselor? Well, I need to make a motion in limine to go ahead and make sure that I can get this piece of evidence into evidence when I go ahead and introduce it during the course of trial. I need to make sure. Or, just the opposite, I need to make sure that my opponent does not introduce this evidence because here are the following reasons. And now the judge will make a ruling, or hopefully he'll make a ruling. Otherwise, he may say, listen, I'm going to reserve my right, or I'm going to reserve decision, and then when we get to trial and this comes up during trial, I'll make a decision then. That is a possibility. But the title that I raised here in this video is, can the judge make a ruling that will affect how a certain piece of evidence comes into trial? The answer is, yes, he can. And based upon that decision, before you even start the trial, that can affect many different things that occur during the course of trial, and it can also affect the jury's ultimate verdict. So why do I share this great information with you? Because most people who are focused on trying to get money as a form of compensation for all the harms and injuries they suffered because of a careless doctor or a careless hospital staff, they don't think about this possibility until they're at trial and until they hear their attorney make this request, and now the judge has to make an immediate ruling that can affect and alter the outcome. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, @oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.